This petition is dismissed. Much of Here I am going to fight the Mr. has of appearing for the respondent. Yes, respondent is granted. How much time? I am filing today, except okay, I submit that you'll be filing affidavit today. This is the matter after the week. Okay, after the week. Okay. The one petition possibly imposing new clause of local clause. That is, a man of X cannot participate gender in one. That's why we have come to challenge it. Thank you. Okay. That's it. With the consent of petitioner, explanation item number 9. But the conduct of the claim is something that's some particular after. Gains out of it. Gain Goswami. Yes. On the prayer for adjournment made on behalf of Mr. P. Goswami, for the petitioner, this is the matter. After 29. 29 July, sorry. 29 July. Obviously. And take for listing of an family matter. May please your lordship, back to mention for listing a petition for proposal. A matter party is the people. Please do. Huh? Devoter. Oblige. So back to act number 10 and 11. In this matters, we are filing substitution application for substituting the response of the other side. We're filing it today. Let the matter come up after the application along with the application. The prayer of Mr. A. Sharma, the Council for Oil India Limited, which is not objected to by Mr. S. Chakrabarti for respondent number 2. S. Chakrabarti for respondent number 2. Both the 10 and 11. This is the matter after the vacation. Yes, Mr. Panik. Now, both of us are item number 12. And senior counsel, Mr. Essential Sir, he was there. So after his remark, he is there. The copy will put for the point after the vacation. Okay, right. On the prayer of Mr. A. Sharma and Mr. S. Banik, this is the matter after the vacation. Okay. Yeah. Okay. All right. Registry. Old matters go to the registry.
But they didn't mention for listing of a motion matter. Okay.
Your Lordship, I like to mention registration number 2552 for listing. Registry. Our officers are present here, District Commissioner of Sonitpur as well as District Commissioner Dictionary present here for DC Lordship. And minus what I compare with Lordship, the embankment of the The embankment has been demolished. On 11th, on 10th, it was demolished. Okay. And 10th of? 10th of June. What? You are the Deputy Commissioner of Sonitpur. Sonitpur as well as which one? Sonitpur is present, Bismarck is also present here. Bismarck is present here. I cannot hear the Deputy Commissioner.
My lord, this is the District Commissioner Sonitpur, Ankur Bharali. The embankment falls under the jurisdiction of Biswanath district. So, DC Biswanath can say, my lord.
Yes. Yes.
My lord, the blockade was cleared on the 10th of this June. We couldn't clear in the earlier date since we had some reports from the local public that there might be some clashes between the two parties. So we had approached the superintendent of police. He had told us that since there was no sufficient force in the district, they had applied to the state. In between that, I had a meeting with both the parties. Both the parties agreed that they won't create any issues, they won't create any problem. We can clear the blockade. So as per their the discussion, we had a concrete conclusion. We had noted in the minutes also. As per that minutes, we have cleared the blockade, and for exhibition of the photographs, we have sent it to our government advocate. Your
Okay.
Lordship.
Okay.
Problem is that on 10, they remove the path. On 11, 9 a.m. by law, they block it. That is also no, by the deputy commissioner, that are also informed yesterday by law. They are doing by my senior friend client.
11th is when?
Yet on 11, but.
This is some,
It's not by the authority, it's not by the authority.
it's not the authority, you
Not
bring
by the
it.
Well, we have informed to the deputy commissioner, Biswanath Saili, but they did not do it, and Saipul said you don't go.
This
Yes.
is a separate issue, as per my lord, so that lordship, the environment was already removed lordship, something was down, it is a defined thing.
No, no, since it has been brought to the notice of the court,
Yes, my lord.
this should be, there is some sticks made. So you cannot do it, you cannot, why don't you demolish it?
Well, demolish is that on 10, 11, they do.
Then why don't you demolish it again? You demolish it.
Well,
You
that
cannot-
but that did not help us because of that, they, learned friends, clients are doing by the.
Yeah, you are not doing this.
That,
Who has done this?
then,
No, the villages, how can they do when already
they
order
filed-
passed?
yesterday we filed an FIR also.
No, no.
Their clients also name is.
So, Mr. Gogoi, I think that the DC, Biswanath Charyali will have to take action. It's just minor thing, it's just a 20-minute job.
Yes, my lord, we'll clear it. We'll remove the obstruction, my lord.
Okay,
We'll remove
okay.
it.
Today itself, they will do.
Today itself we'll remove.
Today
remove it.
itself, okay.
Right.
Okay,
That may be recorded.
Lordship,
what?
one fair lordship. The district commissioner lordship, finish with the program, the excellency governor, one of the, he's arriving in.
No, Sonitpur governor has got nothing to do, the DC has got nothing to do because it's the Biswanath Charyali jurisdiction.
Permitting to let the.
Yes, okay, the DC Sonitpur and DC Sonitpur, you are allowed to leave the proceedings. Thank you for joining.
Thank you. Thank you, my
Well,
lord. Thank you.
And Biswanath Charyali also, please ensure that it is removed
Sure,
today.
today itself we'll clear it,
Okay,
my
so
lord.
both of you can leave the
Right.
proceedings. Thank you for joining.
Thank you, my lord.
Thank you.
This is
Both of them, both of them.
Even if obstruction is there today itself, it will be removed.
That's what he has said.
Tomorrow
We'll
also
record it.
Otherwise, from the district administration, nothing was done.
Okay, right. Heard Mr. N. Bora, learned counsel for the petitioner. Also heard Mr. K. Gogoi, learned counsel for
Still a court.
the state authority. Mr. R. P. Sharma, learned counsel, appears for 8, 9, and 10, assisted by Mr. M. R. Adhikari. Mr. I. Bhattakur appears for respondent number 6. Anybody else? No. Mr. Sharma is not there. Sharma is not there. Okay. Today you're sidelined. Okay, right. The dispute between the petitioner and the respondents was on account of an embankment that had been constructed by the forest department in the fishery that had been settled with the petitioner. The Deputy Commissioner Sonitpur and Biswanath Charyali have appeared virtually during the court proceeding. Mr. K. Gogoi, learned additional senior government advocate, has submitted the letter issued by the District Commissioner Biswanath dated 10/6/2025, which is to the effect that the circle officer Nadwar Revenue Circle, Putia, has issued a compliance report dated 10/6/2025, stating that the embankment separating Saru Dolapani and Bor Dolapani beam has been removed on 10/6/2025. In the presence of DSP Headquarter Biswanath Local Police, Forest Department officials, and Circle Office staff. The whole process was conducted in a peaceful manner and with good cooperation from the local people. I'm going to say that. Mr. R.P. Sharma, the learned counsel appearing for the respondent number 8, 9, and 10 also submits that they were also present in the demolition of the embankment and everything was done in a peaceful manner. Next paragraph. Mr. N. Bora, however, submits that on 11/6/2025, what is this? What is bamboo?
Fencing, right?
A bamboo fencing has been erected where the demolished embankment stood earlier. Mr. R.P. Sharma, learned counsel for the respondent number 8, 9, and 10 submits that the said bamboo structure has not been erected by the respondents number 8, 9, and 10. Next, Mr. The Deputy Commissioner Biswanath submits that the bamboo structure shall be demolished within the course of the day. Well, within the course of the day. Who's up? Anyway. They do it tomorrow, today, that's it. Okay. Then, in view of the above facts, nothing remains to be adjudicated in the writ petition any further. The writ petition is accordingly disposed, is accordingly closed as instructed. The letter dated 10/6/25 issued by the Deputy Commissioner Biswanath and the compliance report dated 10/6/2025 issued by the Circle Officer Nadwar Revenue Circle, Kutia, along with the photographs are made a part of the record and marked as Annexure X collectively. The appearance of the Deputy Commissioner Sonitpur and Biswanath are hereby dispensed. Now you two can go and have chai in the canteen.
Yes.
Chai. You can have chai with laddus. Yeah, that's what I'm saying. Earlier. Going for NIT. What? They were not going. Their allegation is that the deputy commissioner were not going. No, it's in item 15. His cases, there's only one bit. Yes, that will be considered. We are going to take it. You are going to? We are going to take it. So we'll do it. So you take a decision within 15 days. We'll take a decision within 15 days, either this way or that way. Now, what about 16? This is different. This is something different case. This is instructions actually. So this is. Get the settlement out earlier than I. Huh? Firstly, which was issued on 7/7/20. They want to get settlement on the basis of IDA. Okay, so 7/7/2023 had been issued. Just a minute. Was issued, and you were selected. In
I was not selected, but among the minor, there were individuals
My lord, although it was 60% people error, there were 7 numbers of failures. One from the by failure that was cancelled, and other my lord, the six all I did
So there was none from the, none?
one of the
Ah.
failures, and in the comparative statement of the state review, and he has also for my lord criteria, and it's not two of the NIC minor, is given that it was not clearly given that only AGOs can submit pilot tender. So that is what the individual tender is also submitted. He stated if individual tender can also submit, without external permission. And the typically without.
Then what happened?
Then subsequently, official communication was issued to the challenge matter.
Page-
According to which,
page-
29 matter, relevant portion matter.
Yes.
328 is in respect of the present fishery matters for which we have submitted a tender.
Which one? Which one?
Fishery matters number one. In response to NIT, 7 numbers of tenders were submitted. Out of these, 6 were found to be submitted by individuals, one by speaking fishery development SSG. But the tender of that SSG was found intended for non-submission of proper documents, including all deposits. Further documents submitted to the tender were all the individual name of president of the SSG. So, minus, the people communication.
No, so what did it say?
29, madam.
Yes, page 29, yes.
Page 29, relevant portion, third from bottom, madam.
Yes,
In view of the above, we are requested to separate NIC for 3 numbers of different fisheries taken into consideration for the field, as well as government.
yes. So you put this to challenge.
Yes.
Was there any stay? And subsequent to that, there was a NIT of 8/11/23. Correct? And you have not put that to challenge also.
They cannot select lot. Because individual.
They are individual.
Then they have also prepared.
Show me the law, show me the law.
Annexure D, my lord, kindly.
Just a minute, we'll decide everything once. I don't know, I've got the page. Yeah, I've got the number. Which page? Page, tell me the page. No, please show it to her. She has not read the judgment also. Yeah, read. And do you, and
They
anything,
also prepared comparative statement.
no, madam, let us not go into that.
Check my tender now.
Madam, please understand, let us go by the law. Is the judgment of the division bench against you or is in your favor?
This is the fault of the department, but they have.
Madam, is it against you or in your favor? The division bench judgment. Does it cover your case?
But in.
No, but so maybe, but you just tell me later. Right now I'm asking you, does it cover your case? Then, what remains, madam?
But as for the NIT, my lord, they have.
NIT cannot go against the statute. Then,
Secondly, maybe you put that.
Yes, my lord, yes.
That subsequently that NIT was cancelled.
so I'll dismiss it. We are with the registrar. What to do? Unless you guys show me a way out. Okay, you withdraw. You withdraw. Okay, so better. All right, Miss L.B. Chaudhary, learned counsel for the petitioner, says that she may be allowed to withdraw the writ petition in view of Rule 12 of the Assam Fishery Rules 1953 and the judgment and order dated and the judgment and order passed by the division bench of this court in Prabin Kumar Das versus State of Assam and others 2007 CGLP 1017. Mr. P. Sharma appears for the Fishery Department, while Ms. Yudas appears for the correspondence number 4 and 5. On the prayer of the petitioners council, the writ petitioner dismissed has been found. That is item 16. Item 16 and item 15. You right, third, Mr. B. Chakravarti, learned counsel for the petitioner, who submits that the respondent authorities have not taken a decision for settlement of the Kakra Nadi fishery in pursuance to the NIT dated 8/11/23. Full stop. Next paragraph. No, full stop. He also submits that there was only one bidder in pursuance to the NIT dated 8/11/2020. Next paragraph. Mr. P. Sharma, the learned counsel for the Fishery Department, submits that the respondents will take a decision as to whether there is going to be a retender or as to whether settlement is to be made pursuant to the NIT dated 8/11/2020 within 15 days. Next para. Ms. Yudas appears for point number 2. Next, right? In view of the submission made by Mr. P. Sharma, learned counsel for the Fishery Department, the Fishery Department should take a decision with regard to whether they are going to go for a retender or to make a settlement in terms of the pursuant to the NIT dated 8/11/2020 within a period of 15 days from today. 15 days from today. That is the reason accordingly. No, the decision should thereafter be communicated to the petitioner. The petition is accordingly disposed of.
I know.
This is the tender matter. Before I make any submission from there, perhaps my one thing, the lordship, will kindly turn to page 180, the motion. There's a screenshot that we have taken from the website. And even now it shows the obviously financial evaluation.
Can hardly read,
I'm sorry.
can hardly read where? Page
There is a type
180.
of it. Page 187, there is a type.
Okay, page 1. Yes,
Against financial bid evaluation, it is still showing pending. There's no tick mark. So this is an area, I mean, they have not, they perhaps would like to produce the records or tell us, because otherwise, without financial evaluation, how could they have issued the work order? That is one of the issues that is right now. And this is a press, this is perhaps my financial mistake. They can talk on-
work order already issued.
Work order issued, but financial evaluation is showing pending. This is the online tender process. Work order is issued. But then I think probably they have not updated the website.
Probably.
And the difficulty is today the office is closed. I already have told it, so they say the record is there, but the office is closed, so Madhav Dev Piti.
Why?
Madhav Dev Piti is a local holiday.
Did you have,
So I was in fact thinking on this as well. I was thinking of reading the record itself to verify myself. So I saw this yesterday itself. But then they say the record are there in the office, they have to see the record of it. So
I leave it up to you all, what you all want to do.
in any case, for this matter, has come up from voter. And we have already served a copy on. Let me respond, whatever. Let the matter be taken up next week.
I don't know, I leave it all up to you all.
Depends
I'm-
on the letter.
You see, I am ready if you all are ready.
If I am supposed to answer on this, then I need the record. So without seeing the record, how can I make any submission?
Since he has brought up issue,
Yes, but my understanding was they have forgot to.
they have
upload-
forgotten to upload, update, yeah, correct. It appears,
But without intimating, the website, online tender, you're not to the, everything, we are not supposed to personally interact. It is only when they are uploaded it, website, that information is passed to the public. Otherwise, how do we even know what kind of a financial evaluation was taken? So therefore, my lord, this is an aspect. Perhaps we require some.
I cannot argue on this because yes, which proves 4/4/2025. Let me have the record, the lordship, because otherwise I'll not take any submission from this now. How can I?
Correct.
My understanding of the record, they have forgot to update the
The
website.
basic thing according to you is that they did not participate.
Yes, otherwise,
We could not. That is where the case
No,
lies.
according to them,
Yes.
according to you, you could not. According to them, you did not.
And there are materials to show, my lord, how we could not.
because
We went to the extent of, my lord, even making the payment to the bank or making the RTGS payment. The amount are at so much of variance at three different places. They have indicated three different figures for the game. And there's so much in this matter. In fact, my lord, there is another document we would also like to place that on record.
Because the participant and their EFTs have been accepted because the online portal showed.
Just one more document that my clients could lay their hands
But,
on yesterday. If you're not, just have a look at it. Exactly the same work was allotted to the same party on 19/5/2018. It's exactly the same work. And to the same private response. In 2008, this is the kind of scam that is going on.
Because this is the balance work. The work order is
So,
the balance work.
This, if that is so, that is what I was,
No, but who was the original contractor?
the same private response.
Well, yes, sir. If this document is correct, yes.
Then how can it
But
be
if the
given?
work- work-
So,
work is
so,
not-
so if it is the balance work is given, so you mean that the original work was for a part of the
No,
part of the contract?
Because
No, you are not sure, kindly have a look at the work one and compare. This was for the whole school. Perhaps he abandoned it or it was terminated. Therefore, the balance work now has been put to tender
And again given.
again to, and that too like this. There's something very serious going on.
I know we'll have to
This
see.
is
that.
balance
But how does it, but then we'll, before coming to that issue, we will,
If a person, if a contractor has failed to execute and it is terminated, it has to be either of the two. Either he has abandoned or it has been terminated. Now, the same person is sought to be favored by creating all this gap.
no, that is, I understand that the risk and cost clause will operate,
All this,
whereby the old contractor will have to pay the additional cost, if any, for completing the balance work by another contractor. It cannot be done by the same contractor. That's a different issue. Prior to that, we'll have to overcome the first issue.
that's,
Anyway. So if you all want to adjourn, when do you all want?
I am, till 17th, I am not available, any date after that.
I don't know. When are you all available, both of you all?
I have to be in Itanagar for a lot of notes.
Good for you. A lot of contractors want their cost escalation. I've never heard of a contractor not wanting cost escalation. They want a revision of the estimated amount all the time. In fact, they purposely delay their work. So.
No, I want to. Was when from Delhi left the after the, so I am the authority who takes.
I am the implementing agency. They are who have given us the order.
Look, the problem is I was ready. Yesterday you all didn't want it today, but I made you all sit, I fixed it today with the hope that we'll decide it. Unfortunately, he doesn't have the record.
If this particular issue is material, yes, then yes, I think the record. But otherwise,
No, it is material in a way. He's saying that how could you have given the work when the financial bid has not been opened?
the tender process is subject to judicial scrutiny because here is the case where they are
Yes, but
saying
here
I
is
was
the
not
tender
able to
itself.
participate.
Huh?
Here is a case where the petitioner says I was not able to participate. So the point of adjudication would be whether he was stopped or it is on his own. because-
Okay, if you are ready, I am ready. Yes, yes.
Basically,
I'm ready. Look, if you are, look,
before 10 years, I need the record.
look, all the issues that are being brought before this court will be decided. But provided, you see, I don't want to hear yours. And midway you all say that the records are necessary.
So
So,
you're gonna say, person, let me have the record, but on 19th, that if my friend has a problem on 17th or 19th.
On 19th,
on the fair of the parties is the matter on that.
Okay.
At first, they still. Is it an admitted amount?
Yes.
Will the admission again?
It's 60.
1/6.
60. Perfect. I beg to, can this specifically taken up? We are going to.
It's okay. I will just clarify with it. I will wait for you, don't worry. Yes,
Should we 60?
yes. Okay.
Should we all have? Forward. At Boston order, it should be.
So this amount was. So page 60 was the consequence of this order.
Not,
And then there's the contempt.
yes, it's not.
Pay. No, this order of the executive engineer was issued during the contempt proceedings or prior to contempt.
This is a 2030. Worship of contempt. Worship is of 2014.
Okay, let us close.
Contempt case is of 2013.
What is the contempt case number? 2013.
423. That year worship.
Page?
Page 16. Six.
So actually contempt should lie, basically. That really doesn't solve our purpose.
Window of 6 months. Even after that, they are hence lost by interest as well. 20 years. The value which is now actually now are they right to that's all.
Okay, let us read. What is the other matter? Okay. Who is for the other side? But in the item in the other, oh.
We are taking out the measure with the cardiac or the pedal. Those are ATS that is the pedal. They are trying to assess the flat.
After some time, meaning
Today.
today.
No, but question to the effect that so not too much. At the final stage, at least there is a certain man. We are not paying for something.
Who is going to pay?
That's why the ATS stage is the PW. Of the UPS stage, that's why taken up with the partial note for the ultimately those one government, but the proper proposal has to be the government.
Look, that is, you see, that is the very purpose. And then last time you said that the PWD will pay.
No, but ATS said it is the PW, they the instruction.
Correct. Now the PWD says what?
But they certain manner, whether they are, they are the opportunity. But usually.
Who wants to assert it?
PW.
Correct.
Line,
So let the, you see,
only one thing, but they can take it for.
let the GAT and the PWD sit together.
Yeah, that's the. I don't know.
The GAD and the PWD, they have to sit together.
Then also, within my lot.
I'll be sit next week again. Let us be very clear, otherwise no point passing a order and then they not deciding. Mr. Being over, let addiction lady submit that he needs, submit that due to new development, he needs to clarify as to whether the GAD or the PWD needs to pay the bills of the petition. So, sir, on considering the prayer of the learned addiction lady, this court is of the view that the Commissioner and Secretary to the Government of Assam, PWD, and the Commissioner and Secretary to the Government of Assam.
The PWD, let us see the three people. The main authority in the technical. They are working on.
No, let the Secretary also be there.
Both my lord, in that case, my lord, Commissioner as well as the.
It's a Commissioner and Secretary of the PWD and the GAD. Commissioners, no, you say Commissioners and Secretary of the Government of Assam, the GAD, PWD and GAD, along with the concerned engineers, chief engineers, should have a meeting to take a decision as to who should be the paying department with regard to the bills of the petition. The same should be done within a period of 1 week from today. This is the matter on Friday. This is the matter on 20th. Then in the other item you write, it is WPC 5842. No one appears for the petition on. List the matter of petition. Are you, okay. You make it separate order. And you also write this, detached WPC 5842, detached 5267 of 2000. Of WPC 5842 of 2009. Causing a problem.
The board passed by the labor code. So you then take some time, take some time. So some cases of the racket about, take it up, afterwards.
Correct. On the prayer for adjournment made by Mr. A. Rajagopalan and the city council appearing for the respondent number 6. List the matter. Possibility. Yes, what is the case? You tell me in the meantime. Huh?
Running a restaurant along with facility for service of cars. But
Let us see your license. Let us see your license.
there is no such provision of license
Okay.
for that. There is no provision of license for the waiter.
I don't know. I don't know. I don't go. I've never gone to this Pukka restaurant. So I don't know.
It's a provision for the license. So, there are, I mean, our high court, Supreme Court is there. I could also think that there is no provision for license. That's the MCF. So big no. So what I have done, I was running my shop. I explained them. One day they suddenly come to my premises. They got something by and on the ground there, I'm running a 15-minute deadline and
Page.
page number 41.
Yeah?
Page 41.
21. Yeah. Page 21. Of the writ petition.
of request.
In extra 2.
Connection number 6.
Extra 3. And extra 6 is page 38.
Page number 341.
41. In extra 6, in my copy, I did not make it. Probably you have made this petition. Why is it 38? Anyway, you read it by Commissioner GMC.
I will be translated copy of some translated copy of chip issued by the GMT.
Yes, this read. How does it say?
It is that, Mr. By the way, one was running business with invalid trade license and serving hookah without trade license.
No. Page 41. Yes, and that is the.
Why it is
39, not 41.
that means
And in your copy,
some pages and
page different. And I did not make this pagination. You made it.
our.
Yes. Page Page 39.
Like,
Yes.
that is calculated for P of the if there have been after imposing kind of.
Running business with a invalid trade license and serving hookah
Hookah
without
without
TL,
deadline.
without trade license.
There is no provision of trade license for hookah. That is wrong. Then they said it invalid trade license. I'm going to be just invalid trade. But I have invalid trade license. Out of trade license, invalid. Instead of imposing fine in this way,
Where is your trade license? Let us see a trade license. Page
trade license matter. It is page number 20 and 21. Trade license.
2021. Okay.
20 is
20 is the latest.
20 is the last one, and 21 is the latest.
How can 21 be the latest?
My bad.
21 is the latest, yes. 18 for 23.
So, I that I have paid 10 level fee.
Up to 31st March 2024. Okay, and this, okay,
It was 323. They have come to my place.
okay, okay. For business type restaurant.
Restaurant.
So restaurant, in restaurant you can have hookah.
Yes. I can serve hookah cigarette also. By
Cigarette, you can have cigarette. They can have cigarettes in the enclosed space. Is it an open air restaurant or?
It's some criteria there. I have to have a separate smoking just like in the airport. So I have just the smoking area, newly ventilated area.
So that,
That is my note. We have submitted our reply, in our reply, we can see,
page,
we have included photograph. Page number 78, in our reply. Photograph. Separate generated smoking area. With money warning, it is technically warning.
so according to you, for hookah, there is no separate license before.
No. That they will open.
Let us see what they have said in their affidavit.
But now, my lord, one thing I would like to point out.
Yes,
One thing I would like. In my previous like that. Same date like this year, the previous year's deadline, they have charged 8,650, 8,650. Page 20,
Page 20,
page 20.
8650, yes.
But my, in the renewal license, the charges were 2,750.
Why?
Let me note, we have same that if the restaurant is there,
Cost of tomatoes going down.
same license, same restaurant is there, the same, why don't we can see, the previous license was also for restaurant with a big capacity of 30 seats. Restaurant with 30 seats. And the second is also 30 seats. Now they want to say that, they reply, they want to say that we have intentionally done something by filling in the form to reduce the price. So, same restaurant, 30 capacity seats, is 30 capacity seats. We have not reduced the seat for 20 capacity. Now, the lordship have further see that in their page 21 minor. Page 21.
No, license fee, okay.
Page 21 minor, page 21 again.
Yes,
They have charged 2,750 for this year, and for last year also they are adding 2,750.
so why did they take this much?
Maybe there may be some glitch in their website, there may be some glitch in their website, that we can we have filled up the form, we have submitted the form. After submitting the form, the amount payable pops up. That is not under our control. what is the amount payable, the focus in the, right, we pay the amount and the rest is in. So that is not our work. If there have been any problem, if within their website, they have to show, and they have alleged that we have made some wrong information. If there is wrong information, they can come up with the information, what was the information submitted by us. Because website is under their control. Once I fill up the website, once I get the amount, I cannot go back and print the copy. But it is their department. They could have picked that report to come from what is our mistake, number one. Secondly, my lord, if there is such amount is paid, there's a lesser amount is payment. They could have proposed to me. They could have issued it over to me. I could have replied to their support. And thereafter, they could have determined what would have been the actual amount. They could have determined it. So their statement input 1,50,000 a day. Without any natural without order,
So is there a stay order?
there is a
Anyway, so it doesn't, correct. Is there any paid license for a hookah? Any idea?
well, according to checks of what it is, I've scheduled it there, in the there is no paper.
Let us wait for the lawyers, wait for the council. If they think that, then let us wait for your opinion.
Yeah.
After some time, after some.
Yeah.
I,
For the respondent,
what is this matter about? But the paper is just to calculation of the if the tenant of the cluster of profit. According to this law. I'm challenging that calculation or with the notice. So far. Yeah. It comes to phase one. One is zero. But the question for a moment here. Page one is zero. What is it? Okay. I will start the sequence of it. I am telling that the whole process is shit. Oh no, let us see the NIT first. Let us see NIT here. Because I'm, it's from my safety. I'm challenging you that the whole process is vitiated in process is all about very vitiated by stuff. Maybe, but prior to that, let us see what is the requirement. Yes. To go to the, to understand the position of the. Please, yes, fine. Yes. So. This is what this is. And that there are some future development focusing to start with that. What is that? I think of this is that that's it. The one that is not developed for it. For that, partially, partially, that plastic So you are for the Panbari Basbari, the first one. So it was in, it was a technical feedback financial which we have to find. It is two, that's it. Online subscription technical and financial feedback. Technical out online. Five, six, one, two, three, four. That's it. It is that. Actually, that we can have now it dirty. These are the conditions, several conditions. So your 3.2, I think. Yeah, another 3.2. Right. 3.2. Experience in writing a registered voter. Yeah. So, okay, obviously, we will need to consider. So, experience in writing a registered voter. Where is my experience is good. Can I submit it? Now, when we come to page 30. Okay, 30, page 1. This is column and we are going to do rejection. Here. 30 down for 30. First, one is then one. If we have false or consistent or rejected or in a false consistent or fact. So now 13, 13 concept. Finding of the concept, just to go equal to the pay. Then evaluation of the. If you want. Yes. There will be committee, by you can think of all figures of the. Right as A. All the technical. All not the positive. So it is a subjective description of the topic. Now, how did we evaluate this? We have laid down certain criteria. Yes. We have from the NIT, that for following procedure of offering. Step one, after opening of the technical piece, after speaking. Where is that page? Step five. There. Step one is there, within document is not there, or something. Is not there. Step two. That is, okay, cover two. Yes, cover one. And here. That is. Cover. Hold on. Valuation by that. After evaluation of four. That is. That is all right. Now let us go. I think this part two we are all done. So now we can go to the, what I want to draw your losses. That your after technical evaluation on above certain students, right, in the opening of technical, this was done after your evaluation of all the. That's it. And then how they have evaluated it. Number one, number two, particular criteria, number two is experience with running. They assign 15 marks. It says, he has 4 years experience, 5 marks. Above 4 to 5 years. 5. You have it. So, experience part, they have given part, which I. And other, uh, other categories are there, they have evaluated it, parts are already allocated, so other parts. So, if they have evaluation criteria. Now, because evaluation, they have given the formula and they apply to test level. Then 38. Now, that's Okay, so I think we can skip all this. Otherwise, we will never end. Let us skip all this. Let us go to the brass tacks now. Let us go to the, so,
Because once I go to that, I have to go halfway. Then I may have to apart for the without taking them off the.
no, I don't think, I don't think so.
Would be appreciated.
I don't think so anymore. If necessary, we'll go back. If the council is, see, we don't, you see,
Okay, fine, but it's not a problem.
taken enough time, I think.
Just take a note of this particular clause that says 31A.
Page 38.
Rule number 2,
Ah,
if our bid is accepted, to commence the work as soon as reasonably after the receipt of formal work order.
yes,
This I have to go ahead with it.
okay.
So ultimately,
What happened? So the, your
LOI
technical,
was shipped to me.
where is that?
LOI 118. It was all done, whole process was over and LOI was shipped to me in respect of what particular cluster. This is February, 8 February 2023.
Ah, yes,
Now, here it says, alert regarding second para location fine.
performance security.
Sorry.
You have to deposit for performance security
4,444,000.
and annual lease rent. Ah,
LOI, I immediately, when I got it, I accepted it and posted that amount till 119.
yes, then,
119. So I proceeded to cover. I was in the job and it was proceeding. Then what they did, important is, they issued a notice to me. In 130.
one
From here,
thirty.
so what has here? I am on from here. Good, Malan, what you got it, Malan?
Yes,
Yes, subject local service. Development, operation and management contract for running the new structure. Further, Bagan, Napara cluster at one of the park. It some another cluster. Yeah, I guess it also I applied for. So we can go into our letter details. So the Assam Tourism Development Corporation Act, the details notice, 1962, it is 776. I think this for development, operation and management. Contract for running development, operation and management, contract for running all the hard complex at Supporting Kazirama. Here again, they say something about Kazirama, which is of no concern here. But we have concern about is Supporting Kazirama hard complex. The price is different, you have to mention something is different. Then go ahead, please. Two. That person is not inviting you, but you have participate. If that process that happens, all statements submitted by you. It was thing was submitted to your agency pertaining to what in a lab research or those divided services for class agreement section 51 was known to have been existed by you, which did not release all. State agreement, which has accepted that the first person is the absolute part, and for the order to be thus, the circuit is what is heard or the fighter of the university. So here, can be part this day one that I should be the owner of proprietor of the law. Say that I was not the owner or proprietor of the law. But another document that is trade license, particularly to use as the proprietor of River Physics Board. Yeah, this is a subject, trade license that was issued by the authority. There is no as the proprietor. Insufficient. It's false. Insufficient. The PPT wrote an email to say 4556. It is wrong. If you request for confirmation, if you report it, because it is. Reply, you can revert between 5 It is, that we have not done the party for the If the agreement is a lawful and very odd. That we can revert the next part, that we have done with the agreement is lawful and odd. Three, that you have deliberately submitted four documents. Then to and thereby violating laws and regulations. Fighting the distribution to HTTP and self. The pedagogical document opinion expressed. That if you that it is part of teaching up process activity, aims to like the evaluation of physics and on other aspects was revealed that you have higher success with para factor part. Subsequently, you can write as what but that for the career part part of the look on your that confidently submitted oil and coal to illegally
So basically, what I can gather is that you had for a experience certificate, you had submitted this agreement dated 15/1/16, which which Birina Tourist Lodge has stated that it did not exist. So let us see this agreement. Let us disagree.
for that possibility, yeah, that's the paragraph also.
So that
Just notice. So that only two paragraphs.
no, you see that because the long and short of the issue is whether you had executed any agreement with Birina Tourist. Whether that fact, whether that fact is correct or not.
That's not fact. Hospital see what are the documents, what are the circumstances, or the facts on which they have come to a conclusion that it was fraudulent and it cannot be accepted. Because my issue was that experience. I may not have experience, this is another issue. But saying that I have forged certain documents, it is another. possible application.
That is why,
Yeah.
we have to see.
Therefore,
You see,
yeah.
it is like this, Mr. Mahindra. You've got to answer the query of the question. You see, when there is an agreement executed between you and me, and you say that you have executed an agreement with me, then the best person who can answer you is me. So out here also, you have said that you have experience with Birina tourism. So you submitted an agreement. Now, according to you, that agreement is valid. Valid. And let us hear what the Birina Tourism Lodge has said.
Yeah, now that they have inquired it from Virena
Ah,
by issuing the email,
ah,
nothing was communicated to me. Where is that email, in which email, what was the address of the email?
Ah.
And
Ah.
I was responded to.
okay.
Nothing is there.
Ah.
That's not discussed anything.
Ah.
You say that in case of evaluation of certain contract in respect of some similar contract in Kaziranga, they detected that I submitted this also here in Manas. Manas, and therefore they developed a doubt suspicion, and therefore they issued the email, and email answer came. To whom that was displayed? What was the email? Nothing has been mentioned. Now,
Anyway.
kindly see.
Ah.
Now, I will take your lordship to the agreement as well as that deadline. Just say, both are contradictory. What is their plea?
What
Yes.
deadline?
Just say that in the trade license, you have been told as proprietor.
Of the Tourism Lodge.
That this one.
Birina Tourism Lodge.
And the other one, you have been agreement, you have been shown as lessee. How is this? Therefore, suspicion arose. Now, lordship will see whether that was at all a relevant consideration, if it proved, whether that was rightly considered. Whether these documents were rightly considered or not.
No, the thing is, let us be very clear. Are you the proprietor of Birina Tourism Lodge?
I am the proprietor of the lodge when I was running it. Well, like,
No.
when the particular.
No, you can see, running it is a different thing.
Yes,
You see, just because I run something doesn't mean I'm the owner of it. I can run it as a lessee.
yes.
So when you were running the tourist lodge, whether you own the tourist lodge, you are the owner of the tourist
Well, the
lodge.
business I own, but
Business
not
you own.
not
But the tourist lodge you did not.
infrastructure, no,
okay.
that was taken on rent.
Okay, so it was rent, so it was rented property. So you are the owner of the business, but not of the property.
And Rochelle is very right. In the license, I have been shown as the owner proprietor of that business because it is run by me.
I don't know, we'll have to see.
That is
We'll
what-
come to that.
Whether that will in any way have any bearing in my expense.
No, and another, the second part is whether there was any agreement between you and Birina
Yeah.
to run that tourist lodge. We have to see that. So that is the small and short, long and short.
Exactly. What can we come to that agreement for? Page 71.
Yes.
Page 71. What people can you see? This deed of lease agreement.
Ah,
Deed of lease agreement is the 15th day of January 2016. Birina Tourist Lodge, Fatemabad Tea Estate, Kasuwadi. This is the Malat, they are the owner, Fatemabad Tea Estate.
correct.
So that is your first party owner, they are the owners, are specifically so. Now me, second party, me, open theory, so second party, let's see, on the other part. Can you come over to it?
So we will have to see whether this has been executed by you and Birina.
He has Birina. No, it was he and Birina.
They explained this.
Yes. First party owner, page 75. Signatures are there. One is he and the owner, first party, so there is signature.
Is this a registered document?
No. Authorized.
Huh?
Authorized.
Notarized, not a registered. Not a registered document.
But I'm challenging this entire document.
I know, according to you, this is a false document.
Also,
And let
It is, so the monthly rent is 55,000 and it is not a registered document. Yes. So now the issue is whether this is
And then
a valid document or not.
also they also be page 70, right? Before that, please.
I'm coming to it. I'm coming to it. Madam. I'm on list. I know what to be clear for document. This is what I want. So, what we have seen this, the agreement in the Virina. Virina is a Fatimabad district. And then it can be up to age 70, 50. It is a trade license because it should be the number. But the collector stuff, it lives counting here. They like for that, the percent. Village council can give trade license. For that, these are for that. Under what rule is this? For the license issue, that format they have to be not my. They have told me as provider property. They have taken a substitute. This format they have decision to not to run the business. But it is very that I own business, not that's not a problem. But you have got to have you have got to have the permission of the owner of the property to run your business. That is why no, that is why everything hinges on this deed of lease agreement. Sorry? Everything depends upon the lease agreement. Because whether it is a valid lease agreement or. Irina has made a party here. You have not made a party. And they have not come. Is it?
They have not.
They have not accepted.
And not you also see the date of the trade license, the period, that on from which date which is.
2014, 2020.
And that is, lease deed for 16 for 5 years.
That was?
The lease deed was dated, the lordship at the next page, page 71. 15 and 2016, and the term of the lease is for 5 years.
If five, serial number 5,
Five.
So I am here to show whether I have experience of running. Not that something news I have to be evicted or I have taken fees illegally. These are of no relevance at all. I'm coming to it, but basically this was the document. Because permitted to scrutinize it. They also scrutinized page 70. And they were satisfied. They evaluated my tenders. The evaluation committee. The managing director. Ultimately issued the fund. That time satisfaction was gone. Now, when I was allotted, I was in the job, invested money, then they say that no. We are suspicious of your document regarding your. Sorry, we are cancelling and your amount is positive. Whether it is positive law or whether it is not important, it's fair. What is this? VCTC is what? Village Council?
Council, teaching, the council, I have talked to the good to both are put together.
So where is this area?
It is.
VCTC. Yeah, no, is a VCTC account panchayat?
Yeah, they say it is panchayat.
Is it an Anchalik panchayat?
But may not be answered, it's not easy.
So
They
there's a
only call-
difference between a Gaon panchayat and an Anchalik panchayat.
Yeah. Now panchayat.
So
Anchalik
VCTC
panchayat
will be what? Will be what according to you? First of all, it is not a Zilla Parishad. That must be clear. I think.
No.
It is not a Zilla Parishad.
It has to be a Zilla.
So VCTC, I don't think it's an Anchalik panchayat also.
What well, I may be wrong, but to my mind, it will be village council or
Village council,
district council,
can be village council.
maybe under
So
their.
it could be a Gaon
Yeah.
panchayat. It could, but it cannot be a, it cannot be a Anchalik panchayat.
That the PCC area, there is PCC council. So there is a PCC council area. So there, it is villages. Panchayat, they follow Panchayat Act, but not exactly,
The name might be different.
but,
Yes.
but what I feel.
I'm actually, we are challenging. the
Village
document
Council Development Committee. Oh, it's a village council development.
Yes.
If it's a village council development committee, it is not the village council. It is a committee within the village council.
It is under the council. Council development. This council development.
It's different, it's different.
That is,
It is the whole of, it is the, it's Mizoram. Except for the municipal areas, their village councils are built.
it's a village area,
So,
rural area.
but the village council development committee is different. It is a committee within the village council.
Yes.
That's the difference.
Yes, within the village council. So the
Anyway.
development committee looks after all these developments, they if you want.
That's okay.
Yes.
Then,
So,
so,
I'm challenging this document. also.
70 and 71 items.
yeah, they are
Actually,
case,
actually,
they are
the
not
charge
case.
sheet also, because we have actually initiated to do this thing with respect to this false documents, and charge sheet also has been filed, and the matter is pending before the CBO. The next date is on 1st of July for appearance of the accused.
Okay.
I'm going that will take care of, probably, may have some bearing, I will come to you. So, Lordship, is now, I hope, satisfied regarding the issuance of the license. I am grateful that Lordship has given the analogy to the councils where you have also.
No, but then it might not be to your favor also.
No,
At
no.
the end of the day.
Just the first, the understanding of this. I don't think principle.
Yeah.
Not the other way. So, this license for what people can be prefer. I have my particular work because what is there in a particular format, they have told me the owner of the business. Proprietor. And this is the agreement between me and this lot of Fatimabad Tea Company. Now,
Let us tourist lodge. Virina tourist lodge is not even represented by any individual. It is Virina tourist lodge represented by the managing director, proprietor, owner,
that is
nothing.
here it is, here in the agreement, say, the construction owner, he is the manager of that. My instructor, he is the manager of that.
No, as per the deed of the release agreement.
Yeah.
Whenever, say, if I was going to have an agreement with Taj,
Yeah.
Taj will say Taj represented by the general manager or something. Or by Mr. A, ABC or something. Okay, Virina Tourist Lodge, nothing.
Nothing is right, here.
So it's like,
That is not there. That is not there. So that way, well, I do not deny that there may be some defect in this knowledge. That when it goes to the restaurant, they see those issues may be relevant. but not here. Here the question was whether I have experience or whether there was sufficient evidence to show that I was participating in fraud and my experience in running for civil. That is the issue. Therefore, to that extent, limited extent, this document was clear and it was acted upon, and document was made in my favor. Therefore, the notice was issued. I was not keeping well, I could not respond to it immediately, I extended, I prayed for extension of time. But meanwhile, they went ahead with the final order.
And we had cancelled the,
Yes,
from LOI.
LOI. Well, can you see? Meanwhile, I filed an application for review
Review.
before that. Hey, you have passed this order, that's party, page to page, that's what. 142.
Yes,
142. And I submitted document to further authenticate their, to ward off their doubt, page 144.
144.
Yes. This was closed in Indian Agro Industries Private Limited, under which the Fatima Tea Estate Garden, Fatimabad Tea Estate. This tea estate is managed by its property. And they have issued, the senior executive has given this standing to whom it's concerned, this is to certify that this purpose to be student pro, citizen pro, student pro, is a well-known person in Basfali area. And as such, has been given the opportunity to run the illegal laws, property of both Indian Agro Industries Private Limited.
Can you tell me who is the person from Virina Tourist Lodge who signed the agreement with you? The name of the person?
Because the person, here, it's difficult to say, but he, my person, he was the manager, that time he was taking care of that person.
Here's the manager.
Yeah.
You don't know his name.
So I don't remember. Who did that?
I would like to talk to him.
What did that?
I would like to ask him whether he signed. That's all. If he says yes, your case is, no need to go further.
Yeah. What else?
No, you can call him.
I don't know. But
You can,
my colleague and your WhatsApp colleague.
no, I'm not going to call.
So therefore.
I can ask you to call him.
Was there any necessity?
Why not? You see, that will close the entire case. Within 2 minutes, the entire issue is solved.
I understand your one. Whether this honorable court will go to that extent here under this jurisdiction.
No, why not?
Yeah,
This is a writ court. The writ court, under writ court, I can do it. I am only asking you. I'm not saying I'm directing. I'm just asking you, can you do it? I'm not saying do it. If you don't want to, if you said you don't want to.
To develop the thought, which I have, what they are. To what extent we should go it, because go.
Because what I'm saying is that a writ court is not a court of facts.
Yes.
It is a court of law.
Yes.
But I am having my doubts on facts. That is why I am saying, when there is a doubt on fact, and if you want me to decide on the question of law, that factual aspect has to be clarified first.
Oh, wait a minute. I thought to get.
Now they're taking it.
Yeah. Then in that case, as the supervisory authority, the court may always say that the suspect will be considered. You could have taken.
No.
You could have considered.
It is not that.
Oh,
You see.
what sufficient they have acted.
No. You see, prima facie, when you look at the lease deed, there is no name. Whenever, if you are going to have an agreement with the State Bank of India, say for a loan, they are not going to write State Bank of India the agreement between State Bank of India and Mr. ABC. They're going to write State Bank of India represented by the managing director or by the manager or the senior manager, something. How
Those
it is nothing.
those were well informed in law.
Ah.
They know that these requirements are there. They are, in the requirements to be represented by a person, individual person. That is called a loan procedure for those who are expected with the law.
And
Not-
you're,
not
and you,
for everybody.
and you're dealing, and you're a bidder trying to do business involving lakhs and lakhs of rupees.
Hold on, trust and faith.
No, no, no.
So that's there.
May,
Otherwise,
maybe in the tribal areas, not here.
it's not tribal area. The tribal area to be.
No, it is slightly more developed.
It's very.
And when the value is small, not in big. amount.
And the petitioner from Guwahati.
I have still people. Ready? Yes, that is the point. The part of the. I don't know. And there, everything was written in proper format. Then maybe of course say that well, no, that could not have been written there. Not the position, actually. That's it. Madam, don't worry, we, this is what we say. As a profession, nothing is going to happen, we take your vote and go ahead. And go ahead. And finally,
When the dispute arose.
and then this created the problem, the bigger it is. Otherwise, you are bound by, but this thing happens. And more particularly, South India. So, they have something, and they do not comply with that strict requirement of law. So,
But the problem is when you come to a court of law, I've got to look at it through the lens of the law.
yeah, if you look at the problem of the lens of the law, I don't know the speech. The most if they find that apparently, if you have doubted it, that there was no such conflict at all, that's what. So, here, that gentleman and call that person, they can entirely otherwise. Then someone, if suggest will be noticed to me, we will go and verify. If process, further process, if not, then of course we say.
No, you see, this is your case. This is your experience certificate. You have got to prove your own document.
I was challenged by the.
Now they're challenging me.
They have now come up, you know, you and they have acted upon without any evidence, without any material, further material. That is not right.
You see, there's a lot of, like you see, we all know that there's a lot of cheating taking place. Then they run away from the country, some person. Now, this was never nipped in the bud. It came out after a number of years, after a number. So it comes out later. Nothing comes out straight away.
Whatever it may be. Well, I am not entering into core areas of investigation. Who should have done it? How it should have been done? It's a question before it comes.
Okay, anyway, then what else? Let us carry on. I've got my answer.
Otherwise, we should don't have a clear law. Those questions have been appropriate, would have been examined and decided by the appropriate court that there has been a challenge to this. But when in some administrative system, the administrative authority, commercial, commercial, when they have outcome to what of their, they should have followed the system.
They will do it. Yes, okay. Then. And what happened to the review that you filed?
It was simply rejected by, I think, yes, yes, something. So, if you say, same thing, they have repeated, you have forged it, you have done it, but the forgery is serious. Particular people. Forgery, the education of forgery is very, very serious delegation. And here, some amount of proof higher than the ordinary requirement of proof is required to penalize the person. To say you don't have experience in something, to say you have forced certain documents to another. This will lead me to suffer consequences. Therefore, my consequence for your work is there sufficient ground? Is there sufficient material before the authority to say that these are forced and I am guilty of forgery? How can or on what basis this finding was arrived at? My question is this. There may be a case for them to look into and go ahead and decide in some other form. In another, without it. Say that this file police station is taken care of. I will fight it out. But until the court convicts me, can you penalize me?
What? This is not penalizing, they're not penalizing you. They're only taking away the letter of intent.
Well, apparently, though it appears that they have just taken away the job from me. They have forfeited my money. They have forfeited, I am using that amount. And
You can always file a civil suit for damages as per the Supreme Court judgment.
this is another question. The bit that has been done already, I may have to go for. But the question is whether the action was found illegal or the word of arbitrariness. That is not my permission. I know my limitations, my lord, I am very limited question before you. Apparently, there may have some cases for some authorities to inquire, go ahead, find out the detail of it, inquiry they can make. So,
Okay, so this page 150 is the rejection or what? Where's the rejection of your review?
150. Yes, 150. After review, it was communicated to me. First November. Same thing. They have considered definite conclusion that you have forced it. They have not referred to anything else except they did notice to take that they did email. What is that email address to whom it was addressed, who replied, nothing came. Nothing has been disclosed. Nothing has been disclosed. Now, my lord, they are a citizen. They have relied upon. Page 165. 65. They say that they should have given to Greener law. Was it addressed to someone else? Like name or any person?
They won't know who to address it to because
No, therefore,
your agreement doesn't have
as your lordship asked me the question, like he has to appear from the report, that no name has been cited against that of law, who is to be present. So also here, where did it may go? Who created this issue? This question will be done. Here, possibility. Who Birina laws at gmail.com or Birina resort at gmail.com. Whether they're taking an email of
Can this court decide questions of fact?
that is what I'm saying.
Then they should go to civil court.
What? Court to their trying to.
No, so let it go to a civil court.
Well, apparently, I think it's clear. I think because I have they are actually, they are some cost of it. What are some of them? They have control.
Let the documents be proved. Then before the civil court.
What if they want to question against me? Then in that case, they ought to have taken part in the court. What kind of assumption was that they ought to have followed a procedure known in law, which is rather, which will command the respect and command the confidence. And who replied to this? email? Nothing has been there for disclosed. Who is he? We have not done it.
Okay, I think that is your basic case. So basically, you are saying that your agreement, unless it is proven to be a fabricated document, they cannot act upon. That is your basic.
The fellow, the so-called, from the so-called, they have taken a definite stand that we oppose it. They expressed a definite opinion. So the so-called is no so-called that's not. But it was a simply communication of their mind that you oppose it and you are liable to suffer this. And in fact, it has been repeated. So it is issue. My responsible profession is this jurisdiction, because the text is not the court and say, what are the abuse before the action, the case will speak, the committee in the stigmatic in the front. Because it is almost like a blacklisting. Tomorrow, my lord, if I again apply some against some other contract, they will definitely harm me. They will say, sorry,
They will definitely look at your documents fine.
they will go careful, not
Yes.
me alone. But then, kindly see, my lord, how carelessly they have considered it. They have referred to some contract in Kadiroga. In the reference, they have referred to another contract. And in the body, they have referred to a contract in Kadiroga. She have nothing. And then, finally, at the final paragraph, they say, my contract is with passport. They have not taken care of it, looking into all these things. Well, quite clear, my mind
Yes,
is, I what I want to confess to you about. And maybe something, but the process that was adopted was adopted. And the question was not the title, question was not my ownership. Question was not my ownership. Eligibility is only experience. And experience again, well, not in those evaluation criteria of 1 to 3 years, of 5 marks, and 10 marks, 15 marks, this is how they have defined it. If I could not have those, my experience for total 5 years or 15 years, I could not have given that mark. But that will not oust me out to be done.
Yeah, I think I've heard you. I think
I'm
we're here.
I'm grateful. Because Lordship has been, I know the tight form, but until there I see a silver lining. There I see a silver lining. Because why I'm saying it, that is why I am at the cost of institution I am definitely going. The approach which has been made to fertilize me is absolute clear. They could not have come to definite conclusion on themselves and then ask me that you so forth. This procedure is unheard of. This cannot be approved under the law. And I will rely on the decision of the apex court. Take the drop of water.
Yes. Yes.
Lordship, I want to bring your attention of the Lordship to certain documents. The documents are already shown. I just want to show the plot. That's a plot.
Sure.
All right.
I did.
Yes, which para?
It has taken up this 2010, 13.
Yes.
So there are lots of, I will first let paragraph 20. After one, after double quote. Paragraph 20. In the backdrop of these facts, the first question which was for consideration is whether the respondent is cancelling the registration certificate of the evidence acted fairly and in compliance with the principles of federal justice, and also whether the respondent acted with an open mind.
No, this is very clear. This judgment is with regard to that decisions have to be made. I mean, reasons have to be provided for any decision to be made. That's all. Is it?
No, such finding would have been elected. If such finding is already expressed, then it is of no truth. What the decision says. So let me take at paragraph 27. It is no doubt true, paragraph 27.
Yes.
It is no doubt true that at the stage of so called, the person proceeded against must be told the charges against him so that he can take his defense and prove his innocence. It is obvious that at that stage, the authority issuing the charges cannot, instead of telling him the charges, confront him with definite conclusions of his alleged guilt. If that is done, as has been done in these instances, the entire proceeding initiated by the so-called notice gets initiated by unfairness and bias. The subsequent proceedings become an idle ceremony. My full submission, I'm heavily relying on this. Here, the same thing happened. They expressed their definite conclusion and notice, this notice is the entire property, it is also for the law. Therefore, the principle of social justice has been found here. I have not been given opportunity and they have taken this decision on their own. Justice is rooted in confidence and justice is the goal of a process judicial proceeding also. If the functioning of quasi judicial authority has to inspire confidence in the minds of those subjected to its duty, thus authority must act with utmost fairness. Its fairness is obviously to be entrusted by the language in which charges are called and conveyed to the person proceeding against. Therefore, the authority has already taken an opinion, a reserved opinion, and they have repeatedly said till the final order when it is reviewed. They have not considered the other documents which is opinion, which was issued by the senior executive officer of that particular laws. That there may be something which was not clear earlier, but this document gets things clear. Yes, document makes the things clear. But here, what you can see, 144, this document shows there are questions. Because they have started that, yes, you are here. You are here, you have to explain.
Okay, I think let us hear the other side. Yes.
May it please your lordship.
Yes.
Your lordship, I bow down to the observation of the prior lordship. Lordship, I just want to bring your lordship's attention to certain points in the entire petition and also the evidence that we have submitted. Lordship, first in the page 25, the tender document.
Yes.
Tender document, your lordship, my has also already read it out. So it talks about development operation management contract. Your lordship has page 25.
Yes, yes.
So for the newly constructed Panbari Basbari cluster at Manas National Park. The reserve price, your lordship, the reserve price is 3,50,000.
Correct.
So it will be over and above. So the price quoted by him, it is 4,40,000. 44,000 he was quoted. He quoted and he was the successful bidder in that as part of the quotation sector. Now, this is the charge which is per month, and it is not for the year. This is the amount per month. So that is one point. Now we come to the next page, which is at the experience, which is at page 28. 28, page 28, okay, Isaac?
Yes,
Which is again, my learned friend has already mentioned, para 3.2, which is the experience in running a registered house, guest house, etc.
Correct.
for a minimum of 3 years.
Ah.
Thereafter, your lordship, I would like to draw your attention to page 31, para 22.
yes.
The lease, para 22, the lease rent basically has to be paid annually. So it is like 4,44,000 into 12. That is the lease rent, and that has to be paid at the time of signing of it. So this is an accepted document, and that is the amount that is about 48 lakh, 44,000. The amount is mentioned. I'll get to that amount.
Now, why have you got this?
What is
issue up?
because he has paid only 4,44,000, not the rest of the amount.
But
So
was, what was the show cause notice with regard
So
to that?
what happens, if I bring your attention to this, what happens throughout is that there was a typographical error when he sent them. He was selected, he submitted 2 documents. The technical evaluation committee chose him. Now what happens is that thereafter he's supposed to deposit that amount and then take the handover of the property. Now he fails to deposit the entire amount. We immediately write to him saying that there was a typographical error as you already had seen in the bid document itself. The amount has to be paid for 12 months and not for the monthly. So kindly clear the rest of the amount. Initially he responds that all the letters are there, saying that he's confused, he doesn't understand. Then he said, okay, give me some time. In the meantime, what happened? There was another tender that was quoted, that the tender that they are mentioning in Kaziranga for the Pathori log hut. That tender document we have mentioned, it is mentioned in the so-called notice. And thereafter, we also mention about that in the affidavit in opposition that we filed. In that Pathori log hut, he submits these 2 documents again, the Birina Tourist Lodge document and the trade license. So what happens that the technical evaluation committee of that Pathori log hut, they noticed that a person who has already claimed to be a lessee, where it is clearly mentioned in the lease document that Birina is the owner, thereafter he claims proprietorship, which means ownership in the trade license. So they become doubtful. And thereafter they send him an email asking that kindly clarify on this particular
Those
point.
Potari Lockhart Evaluation Committee.
Yes, they find out. And then they come to know because it is again an ATDC. They find out that the same document, on the basis of the same document, he has procured this particular Panbari Basbari tender. And thereafter they ask him this question, can you give a clarification on this? In the meantime, there were also letters all the time to him saying that kindly deposit the entire performance security. And he had not taken over the formal handover of the thing, but that not happened because he has not even submitted the performance security. Thereafter, what happens? In the month of May, we send him a letter. He doesn't respond. We also send this email, the email that my learned friend had mentioned, the email to Birina, which is at page 189. 189, which is also actually a part of her.
Email to Birina and to petitioner.
Yes, email to petitioner was before that. No, where is it? I'll just get that. That email was email to Birina asking, do you know about this particular, which was already read out. I will not.
Email dated.
Email dated 4th May 2023. So do you know about this lease document that was submitted? We shared that lease document in the email and giving a response back in next page at page 190. This is concerning the lease agreement between Birina Resort and Mr. Chaudhary. We have not come in talks with any party of any such. The agreement is unlawful and here is void. On the basis of this, actually, we go and file an FIR And that FIR, thereafter investigation was conducted where the IO,
Police case number?
police case number,
FIR dated?
FIR is dated, look, it's 25/5/2023 FIR, and the FIR number is 219 of 2020.
And police case
And-
registered?
Yes, it is
What?
registered.
What
So
is,
that is, thereafter charge sheet was formed. And
what is the police case number?
police case number is, 1 minute. Page is 191, your, it's page 190.
It is Paltan Bazar.
Paltan Bazar, yes. Because, we are in ATC office is in Paltan Bazar, and the petitioner is also actually from Paltan.
Paltan Bazar PS case number. This is FIR number.
The PRC number, case specific number is 2495 of 2024.
2495/2024 under
Under 420 and 468 of IPC.
yes, okay, then
Thereafter, Lordship may refer to page 256, which is an additional document that we filed.
actually, just before that, Kathori Lockhart NIT
Yes,
dated
Kathori Lockhart MIT.
issued by the AST by
ATDC. That NIT was dated 7/11/2022.
so this is prior to
Prior to. So, but that, the technical bit, et cetera, were not open in that, and it was only later on it was found. So in the meantime, this tender in 2023.
so he used both the documents with both the ten.
Both the tender, and that's when they found out there's a discrepancy. And we kept on asking him for his justification. So he kept on evading replies. He said that I'm not well. He said he's not well. Thereafter, he says his father is not well. That in that manner, he keeps on asking for 2 weeks. It continues till August. And that was our peak season. Our season was starting. So, and in the meantime, we canceled his in August itself, we canceled. Thereafter, we initiate a fresh NIT. He sits down. He doesn't reissue a fresh NIT for it again, Basbari cluster. At that time, he does not object. He sits down till the time Mona Lisa Communication, who is running that cluster at present, they are given the LOI. There, at that time, he comes before this honorable court on 18th of
So it's
December.
still being run by Mona Lisa.
Yes, it's been run by, and he never took over actually. That was never handed over.
So Mona Lisa is right now running the.
Running the,
So Mona Lisa is a party here.
no. They're not a party.
You're not a party. So what do you want? So Mona Lisa, communication. Has been running, huh?
Modern construction.
Construction. Has been running it since when?
18/12/2024, David issued the letter LOI.
For a period of,
Again, the same contract, I think for a period of, again, the lease length will be given 3 years, I think. 3 years.
so they have not been made party.
Yes, obviously, but Lordship, I just missed mentioning one particular document which was relevant, which is the affidavit that the petitioner submitted along with the bid document. That is at page 91.
Mona Lisa construction on the basis of fresh NIT dated
Fresh NIT dated. But one letter. 24/8/2023. And letter
Huh?
24/8/2023.
NIT.
And I said, and I,
Okay, and LOI issued in December.
December LOA was issued. 18/12/2023.
And the possession of the property has been given.
On 23rd, they accepted possession of building.
Possession given on 23rd
Right.
December 24.
And Lordship, I just want to draw your Lordship attention to page 92, which is the affidavit submitted by the petitioner along with the bid document. It is in,
With the two documents,
yes, with the bid document, with the document that we submitted.
with the bid document.
Yes.
Yes,
The affidavit is at page 92.
yes,
At the next page, that is paragraph number 5.
yes.
That is specifically stated that deliberate and malicious submission of bid with false declaration shall render such bid non-responsive, which shall be summarily rejected without assigning any reason. But of course, your lordship, we had there are a lot of open for that.
That is,
That is,
that's they're going to deny. But then basically your case that it will be with regard to that what is that?
performance.
No, that.
The
There is a
EC
clause.
and the proprietorship. Our main issue was that those are false documents, because a person who is a lessee on one side cannot claim ownership of the same property.
So it is a bid rejection in page 30, clause 10.5. False or concealment or misrepresentation of fact of the bid. Will entail bid rejection. So that is their option. So that affidavit, that is here not.
I doubt it.
That's what is.
That's it for my. These are my comments.
No, that's behind.
If I just draw the charge sheet, if I can draw the attention of the lordship to the charge sheet.
Yes,
Sorry.
yes.
Charge sheet is a page 256.
Page 256, that's it, yes. Yes,
Yeah, the lordship, it is at page 258, para 10.
just a minute, of course. Yes, correct, yes.
That is the additional affidavit filed by ATV.
Correct, yes.
Para 10. 256, page 356. Annexure R20.
Yes, page 249, that's being alarmed. That's being alarmed.
258. It is the charge sheet, it is final form under section 170.
How does the, it is the charge sheet?
Which is right here. Because
Addition.
investigation was conducted by the IO where the
Charge sheet is at page 262.
So the charge sheet is this page.
Yes, I know.
This page. The lordship, the next to next page, which will be the paragraph 10. You have to check. Paragraph.
Two,
That should be, 260 is the page with a lot of. So I think.
260 is behind. No, 262 is the charge sheet, itself. Then,
264. That will be the last document.
yes, 264, yes.
264 para 10.
Yes.
The facts disclosed during investigation.
Yes,
Then, so if it says during investigation, examine the informant as well as witnesses and recorded their statements under section 161 CRPC. Visited the PO, draw up a rough check note, seized the validated documents, examined the alleged accused person, and recorded his statement under section statement under section 161 CRPC and released it under section 41A CRPC notice. During investigation of the case, found prima facie as well as corroborative evidence against the accused person, namely Pankaj Chaudhary, under section 420/468 IPC. So this is the paragraph I wanted to read. Now, the petitioner has given a response to this additional affidavit. The response is at page 266.
Just a minute, this PSK number is 576. Not, you have given 2495, it cannot be, it is 576 of this.
I'm sorry, I apologize. There was,
Ah.
there was a mistake in mine.
Yes. Yes,
So then the response to this is an additional affidavit that we filed the charge with here. To as a response to this additional affidavit, the petitioner filed a reply. And the reply, and reply will be now at the.
the reply starts from page 265 in my copy.
265, the para 20.
There are 20,
Para 20.
there are 20. There are 20, in my copy it is page 272.
So, your lordship, so he has, so there was a statement by the IO itself that the accused has been examined and thereafter the accused was released. It was clearly mentioned out there. Here in this paragraph, we mentioned that as regards the statement made in paragraph 33/34 of the additional affidavit with regard to FIR number 219, 2013 is totally false. More so when the admitted position is till date is no cognizance being taken by the court as mentioned by the respondent. The deponent has no knowledge of such FIR, and it is only through this affidavit deponent has come to know any FIR was given. So I just want to bring this to your lordship.
So he's got amnesia now. Anything else?
Lordship, I've got cases with respect to that.
Evening.
I didn't stop with the cases. Paragraph. With respect to basically the cases deals mostly with tender, in the case for tender, it is a contract and it is,
Yes,
and if your lordship would require, give a small written submission with respect to that. So it is mostly of judicial review, but I don't think so. This is was submitted by my, so I think your lordship, it only talks about, so the interference of the honorable court in respect of judicial review. So I'll just rest it. So it is not required here. It's not required in this case, your lordship. I will just rest my case on the submissions made by. Yeah.
anything else? That's all. Anything to add, Mr. Mata?
Yeah, Malas, I think that, this 21 day. I can probably,
Rohan.
Yeah. I think, that's probably, like, which started, that's not something.
Correct. Correct.
Political power, 41 days.
Correct.
Where a 46.
Correct.
Right, the power given to the family, and it's a belief. This now Mr. The power retained by the MD. The power retained by the MD. The appeal gives the power to cancel it. Yeah. But this was done by.
Anyway,
Oh, it's,
yes.
especially when the contract was decided independently by Patent Committee having considered everything. Was it not required for them? I don't look at the safety code. If it was wrong in there. That is other, some committee sitting somewhere else in other, they have effort to. Then they have done it and that's the.
But their case is that they are the same authority.
Same authority definitely cannot be. Why is that so?
No, it's the same department.
The fact. Yeah. The better sense, the organization is there, but they function for certain person. Committee wise, whether it is same person, same thing.
No,
Same
but,
set of
but,
person.
but then the decision with regard to a document in some part of the world, when decided, when it has been submitted in another part of the world, whether it is a valid document or not will remain the same, and especially when it's within the same department.
After when, if that authority has already completed the process by taking into consideration all relevant aspects and subject conclusion which is in ultimately, then this fight is the
Another thing now, all these exercise that we are doing has basically come to naught.
So,
For the simple reason now that there's another person running the
yes,
thing.
that is what I'm saying. There was an interim order of this order before.
But it was passed,
Yes,
it was after it was handed over.
No,
It was handed-
that was.
The LOS issued and we were given summons only later.
No,
we
you see,
had-
no, you see one thing, the interim order was that if the tender process was not finalized, the same shall not be finalized. And final allotment order should not be in respect of that tender notice. Now, what they've done, they're smart also. So they issued a fresh tender.
No, that was.
So that fresh tender, there has not been stayed. That's correct. So-
That tender itself, which was quoted, wherein with,
Mona Lisa,
now it is the-
Ah.
That tender was put to play. That affects the report. Yet, what was the price
What
tender-
happened to that, what happened to that case? That has been put to challenge.
Yeah, itself. Yeah, itself is very good. Yeah, itself. Challenge was made to vote that they cannot go ahead with the first tender.
No, but then
But the
there is no,
LOS
there is no,
Issued.
there is no stay of the first tender. And Mona Lisa is also not a party here.
That time, Maharashtra was not in Kipta.
That
That
was-
is what, there is nothing.
Can you see our prayer?
Let me see.
Because later on they have done it, Bharat, maybe they have started with the Guru. They are not coming forward, disclosing all these facts at the time when the court was dealing with.
at that time,
No agreement was signed, this honorable court, your lordship also had the occasion to hear it.
The pending disposal as the notice is that has not been said.
and notice was not issued at that. Notice was only on that day already LOA was issued. 18 is the date of the order,
13, anything has
Okay,
been now
okay,
submitted.
okay.
and 18 LOA is already issued.
Anything, anything has now been
LOI was issued
On 18,
on
18,
18th,
18, yeah,
18th,
18 Feb.
prior to this order.
Matlab, LOI,
LOA.
LOI, yeah, or the interim order was on 20th.
20, and that LOI issued on 18th, 2 days earlier.
And when the tender was floated, the case, they have not filed the case.
With the information.
Has already happened.
No, but then you see on 20 only, Mr. M. Ketria, Learned State Council,
Yes, foreign council. So we were not represented. We
No, no.
came in later.
but he accept, anyway, Except for all respondents.
All respondents.
But whatever it is, on the first day, he won't know anything
Yes.
unless he gets.
That we just will not hold water bottle.
Anyway, that will, I will decide. That aspect I will
So,
decide.
you know, time. Go ahead, yes, you have to say, you get up, this is something.
Anyway,
Otherwise, if the board exercise pertaining to my, disqualification goes wrong, then the rest will automatically fall. Rest will automatically fall. That year lost it. Full time difference. If ultimately the earlier part of their proceeding, earlier part of their action falls through has been arbitrarily illegal, then the subsequent part will automatically fall. There, now, Ricky has to submit the rules and throw it without quota.
anyway, I think I have heard. I think we have taken enough time.
I have not taken much time for the working. So I, reply to that person. That reply, that what you have said, that in this particular concept, thing, dependency has been done to verify all this. Nobody raised the question also. But in some other subject, they have taken up, and there, they have taken the action.
Okay, right. Okay, right. Third,
About one small bit, the contract for Mona Lisa is for 5 years, renewal for 5 years,
5 years.
5 plus 5. So first,
Okay, right. Heard Mr. K. Manta, learned counsel for the petitioner. Assisted by Mr. Huh? K. Manta. Also heard Ms.
P. Barwa
P. Barwa
for 2 to 5 APDC,
for respondents number 2 to 5.
L. Bakchi.
You are a senior. Then, who appears for the tourism department, number 1? Miss Yudas appears for respondent number 1. No one appears for respondent number 6. Right. The petitioner is agreed with the, and I have prayed for. So it is prayed for setting aside. The letter dated 1/11/2023, issued by the respondent number 4. Canceling the Yes, yes, challenge in the prayer you said 111. Where is this 111? No, that is not 111. Huh?
The second
That they
cancellation.
know, after you, they have passed that order.
I said the second
Second
cancellation.
cancellation.
You have not challenged the first cancellation.
150.
You have not challenged the first cancellation. You have not challenged the initial cancellation. You have only challenged the rejection of the review.
Well, take me.
No, no, that is not the same thing.
If I approach sufficient.
No, no, that, you see, that is,
On the
And-
same ground,
Whatever, I just say, you know the law better than me. You're a senior counsel. I think you know. When the
so
preliminary,
on that ground, of course,
you have no challenges 8/8/2023 at all.
therefore, probably not to say fine.
Anyway, I will, but you know that if the preliminary, if the initial challenge is not made, how can you challenge the consequential or the secondary notice?
So therefore, the constitution not for to review. And they have repeatedly said, therefore, I have to.
Anyway,
Very little different features.
anyway, your juniors need to, I think,
Well, I've taken note of, but then I have told some sort of here in this case, so people can see.
have to be more
It
careful.
doesn't make any difference because the down surface.
Counsel, you-
The first one,
if you don't, if you don't challenge the main thing, but anyway, we will accept. Only thing that luckily I started dictating here. Otherwise, I would be looking for this 111. Anyway, right. 111, 111, 2023. Issued by the respondent number 4. Okay. By which the petitioner review of the earlier cancellation notice dated 8/8/2023. Has been rejected. The next one, the petitioner's case in brief is that in pursuant to the e-procurement notice, by detailed notice inviting with bracket QCBS, bracket was dated 3/8/22, herein after referred to as DNI. For running, for development, operation and management contract for running the newly constructed Panbari Bari cluster at Manas National Park. The petitioner had been issued letter of intent dated 8/2/2023. At the rate of, at the annual lease rent amounting to rupees 4,44,000 plus GS within 15 days of receipt of the list. The petitioner submitted rupees 4,44, 4.44 lakhs by, fixed deposit, by way of fixed deposit. However, prior to possession of the, what do you call it? Possession of the, what is it called? The law came over. Possession of the park being given to the petitioner. A notice dated a notice dated a show cause notice dated 24/7/26 was issued to the petition. Okay, hearing for notice judgment is there. Okay, no time. Yes. Yes. Mr. Parva. Parva. Yes, sir. Yes, sir. That particular cover without any dedicated post that there was not running with the dedicated booking. That is the dedicated thing. Was any notice issued to the that checking while checking that particular it was found. What is take up my affidavit, madam? What you stand there and I make the photograph on that particular thing. My affidavit filed on 6/2/2025. And it is number 55 and extra. There are photographs, and here in the entrance itself, so what happened? There is no designated place for smoking, either smoking in your home. No, you see, I'm not on that. That is not the issue. You look at page 39. Yes, I think that was while it was that particular day, the photographs were taken, at the same time, the trade license was found. The trade license was to be the trade. That's why the fine is there. For that, my lord, there's a document available of the so it was filed by a partnership file. So-called partnership file is not the it's the main preliminary issue I am taking. So what is not here that preliminary issue? No, just tell me one thing. Before your preliminary issue, my preliminary question is, here said that ward number 10 running business with a invalid trade license. Now that is one. Number 2 is and serving hookah without TL. What is mean by TL? Page number 39. Come to page 40. Here, trade license. Show me where is the requirement of a trade license for hookah? The trade license for anything. Show me where. Hello. So is 180 of the TO. You see, Mr. Council, for hookah, they're not selling hookah. They're smoking a hookah. They're running a restaurant on the side of a trade license without a designated smoke of the for without some smoking area. And they are usually trade license there. So basically the act is basically a smoking. Usually trade license and also smoking area. There is no smoking zone of that particular. Where have you said that? Where have you said that? What you stand to? Why this is like fine was imposed, my lord? What you stand to the page number, my petition page number 20 as well as
21 together.
Yes, on to page 20.
Page 21 and 22 of the.
Yes,
What with the schedule for trade licensing, schedule 4 of the act, where you have to pay the trade license.
let us see the schedule.
There is a schedule.
Yes, what does it say?
You. Page number 184. The fourth schedule, Manu. The trade license, all 184, 184. Okay. 184. Are notified on March 2009. Before the schedule, the price of their value of the business they do it, that trade license is fixed. So, my lord, they have to pay the trade license, fees for the trade license. He pays 20, my lord.
So which 184, which one?
Well, category 1.
Category one.
Category 4 is category 1 because it is the higher side, more than 7,000, they have to pay. It is in that particular district, 7,500. They have to pay 7,500. The notification was later on it is notified to on 1st June 2009, it has come to 8,650.
How does that matter? How does that have any connection?
That is the invalid trade license I am trying to say.
Yes. No, you see, invalid trade license is different people. Your hookah trade license, where is that?
But why don't we do it? Cost is up to now 180, it's on 180.
Yes.
Page number 80.
Page number
80.
yes.
So 180 page number, every business has to take up for it. Yes. License to be taken out anywhere. Every person who exercises in the city, whether for himself or by his whether of the profession, trading, trade or college. In the fourth schedule, they'll annually take out a license for the first year of April or within 1 month of taking out the process. You have to take out annually these trade license, and you have taken out the trade license.
So they have figured out the trade
Trade
license.
license. What will start to page 20? Page 20 has taken out a trade license. Yes. For the year 2020. Yes. What we see that year 2022-23 the amount. Yes. It is 8,600. 8,650. Yes. 8,650 is the maximum amount. Yes. So now in the next year, these are online. You have to click it and say the page. Only that this is the business time running, and you have to pay it. Next page, final page is 20. Yes. He has not put the correct information. I think that put the trade license going down to 275.
So tell me one thing. What is the difference between an 8,000 license and a 4,000 license?
This is the amount of business they carry out of say that I'm doing a business of about 10 lakh to 20 lakh. Then that is the maximum what they have to pay.
Okay. So what is the so this 2750?
The less he has paid a less amount, doing that yes is low.
Yes, but then what is the limit? What is the limit of a business that a 2750 fee can do, license can do? This license fee of 2750 will allow a person to do business with a turnover of how much rupees?
So still I can have to go to the schedule.
Yes, let us go to the schedule.
Page number 154.
154,
184.
184. Yes.
Company or associate, OT, paid a capital of which is equivalent to 20 lakh of the fee or upward and create a company connector. Here's one. This. So if 20, we give business of 20 lakhs and above, he has to pay the maximum. Okay, maximum. So here he has, he has 2020 has done. And in the subsequent year, in next year and thereafter in 23, 24, he has, these are online, he has done the mistake and reduced that amount to.
No, Mr. Kaushal, one thing. What is the amount of business that a license fee of 2750 can do?
750.
Yes,
So that that online portal has to be checked.
Mr. Kaushal, it's a very simple question.
His business is depends upon
Mr. Kaushal, that is not the only question. The question is, how do you know how much business he has done?
he has to disclose it on the website.
Where have you asked him that what is the amount of business you have done? Have you asked him that you have paid only 2750 license? Now, what is the amount that you have paid? What is the amount of business turnover you have got?
He has itself has stated in the earlier.
Things like this. When you say that you can do business for 20 lakh, if you pay 8,000 rupees, and if you can do business for 10 lakh, if you give a license fee of 2,000. Now, if he gives 2,000, it is your duty to check whether he has done 10 lakhs of business or more, or you have got to ask him, have you done 10 lakhs of business or more? If you don't know, how can you just on your own just ask him to pay?
Online hotel, he has to disclose it that I am doing a business.
So is it your finding that his disclosure is wrong? How much has he disclosed?
He has disclosed so that amount has come down.
Amount has come down, but how much business is he allowed to do in a license fee of rupees 2,750?
That clearly, but that online portal has to check whether and that query. What is the amount? But when he says that the amount I have doing a business of 25 rupees, in the earlier that.
So what, a business cannot suffer? A business cannot go down?
Because he has to,
What kind of a argument is this?
because he has to take in the very, very fast time and then a month of April, he's doing a business of second.
So it can go less. You have accepted his fee of 2,750. And that is not your case in your receipt. In your receipt, it is not your case that he's doing a business worth more than what is allowed. That is not your case.
In your case, what
Where have you said? Where have you said in your affidavit? Where have you said in your affidavit that the license fee that he has paid is not commensurate with the business turnover of the petitioner? Where have you said that?
on a lot you turn to fifth, my benefit, phase number 60. The paragraph number 11. The figure to statement more in paragraph 8 of the same capital of operation of bank by the online portal that goes to the payment of this trade loan. The payment of this trade loan is online by the in which self-initiative act is the corporation and cannot be attributed to the fault of the website. Portal, yes, of the party mutual corporation is which is operational for ease of doing business. Is it a portal which has been for doing ease of business and he has to
How much is he supposed to pay?
supposed to pay 8,600
Why?
because he is the place that it is the maximum 20 lakhs and above. The 20 lakhs and above, he's being a
Where is that document or where is the rule, or where is the document or some proof from your side that he's doing business of more than 20 lakhs or 20 lakhs of business? Where is that?
That in the portal, he himself has to say,
So how much did he say in the portal?
well, if that portal possible fee.
No, you see, you said that in the portal, he has to say how much business he did, correct? He has to disclose. How much has he disclosed?
Yes, because less so that.
How much is that less? Is that 1 rupee 50 paisa or 2 rupees or 2,000? How much?
That is not disclosed in the affidavit, Madam. That portal,
Then how did you fine him? How did you ask him to pay a fine without proving your case?
was initially when he started the business, he is giving it more. And
So what? So what? So what? It depends. Today, in this year, you might give your income tax of maybe 10 lakh. 5 years down the line or the next year, you might give just 1 lakh. What? Does it mean that just because they're giving your income tax of 10 lakhs today, that it will have to carry on being 10 lakhs and above? Then what kind of a logic is this? As if that all businesses will always prosper. Everyone who gets a salary, his salary will never go down. What is this? During the COVID times also, everybody took less here and there in various companies also. And then there are so many cases of businesses failing. Businesses usually, they're more apt to fail than succeed. Especially the eating business. You see, restaurants are one of the most, have one of the highest failure rates. You please talk to Uncle Google if you don't know. So, you see, you have got to justify. Okay, he's giving less license fee. But then you've got to justify that with the disclosure, whether supposing he discloses, yes, this is my turnover. Now, his disclosure, why do you say it's less? What's the proof? And that's a different issue. The issue is whether hookah needs a different trade license. Where does it say that? Then, if it doesn't need if it doesn't need a different trade license, does it need a trade license different? No. Is a trade license, correct? Okay, that's a different thing. But according to you, hookah doesn't need a separate trade license, correct? Correct? Yes or no? Correct. Correct. Now it is all live stream, so you can check it again. What do you say? Now you come to the receipt. You come to the receipt. Again, page 29. Sorry, page 39. Come to the original, page 40. Come to the page 40. Serving hookah without TL. What is this TL? Is it trade license? Then you just said that it doesn't need a separate trade license.
With an invalid trade license, serving hookah without, meaning that trade license which is previously is not adequate.
It is not adequate. So show us why it is not adequate. Why it is not adequate? What is the disclosure that he has made? And how much will a fee of 2750 enable a businessman to do business? How much? What is the turnover requirement? Is it up to limit of 10 lakh, 5 lakh, 6 lakh, 2 rupees? What? You just cannot charge anything. How can you say 1,50,000? On what ground have you charged him 1,50,000?
Is under section, which is newly incorporated section number.
Yes.
40. I already stated number. 404 in bracket 1.
Yeah. Show me the.
Doctor is not signing this up. That is a joke. Incorporated in 2021.
In your affidavit, yes, sir.
Yes, sir. Who has helped? So every day, like, there will be kind of cycle there.
And when was this incorporated?
It was 2021.
Okay, now, whoever contravenes any provisions of any of the sections, subsection clause, now which provision has he contravened? Or fails to comply with any requisition, or fails to comply with any requisition lawfully made upon him, and under any of the said sections, subsections, or shall be punished. So, first of all, you please show which section or provision has he violated?
Section 1 is very likely, my lord, just civil code 1. So 180.
Section 180.
180. You have to, annually you have to take out a statement.
I don't find anything. And where is your requisition to him not to carry on with his violation of the particular section? Where is your requisition to him? Any notice was issued to him?
So the surprise thing.
Surprise check. So, where is the, I don't see, section 80, which part of the section 80 has he violated?
The section 88, trade license is taken. You then it can trade license. Yes, taken as a trade license.
Then,
What is insufficient? If repeat. Serial number 1 of that code schedule. Possible. That is
serial number 1 of code schedule.
Code schedule. That is what page 184. That's what is just read it, my lord. The annexer 1. Annexer 1.
Mr. Council, I don't find any case, and I don't find anything in your. First of all, there is nothing in your affidavit or anywhere saying that his license has got a limit of this much business. And that he's doing a business beyond this. There's nothing like.
What is finance the page number 194. These are the annexer 1. That's corresponding the serial number 1. These are the business which is
194.
194. Annexer 1. Annexer 1, the category of business into class 1 category. Sir.
Page 194.
191. Yes. These are class 1 category. All these are come have to pay the maximum amount of. You know,
Yes.
it's luxurious restaurant in house. No. And even by not lot of here for that is
What is the difference between a luxurious restaurant and a non-luxurious restaurant according to you?
it is for category and person we are having that of 20 lakh rupees. So yes,
That much so I know. That much so I know, 20 lakhs. Now what is his business? How much business does he do in a year?
well, that disclosure getting making in the portal.
And another thing, Mr. Council. This talks of proposed rate is 7,500.
That is suppose rate was 7,500. That's that particular.
Correct. And why did you take, come to page 20. Why did you take 8,650?
So there is amendment in the 1 June 2009.
Huh?
1 June 2009. There is amendment.
First June 2009 amendment was made. Show me, where's the,
That is not in the book.
and this was paid in 22.
No, that is not in the book. That's why the amendment, it was hiked to 8,600.
Huh?
That is hiked to 8,600. That was high.
Okay, then why have you now accepted 2,750? Where is that?
2017, it's the online portal, you know, doing business, so you have to pay it online.
Mr. Kaushal, when you are relying upon this coach schedule and the rates there,
Yes.
there is no rate of 2,750 also.
Subsequently, it has been changed, June 2009. And
Where is that? Where is that? Where is that?
That part I don't hold it, my lord, that it is one concept, my lord. That amendment has been done, that they are doing it, everybody is doing it on online portal, they have to disclose themselves.
No, no, you see, you also cannot accept money just like that. If they have given you more, then you should return. If they are giving you less, you should demand that.
That's
Now, so you cannot have your cake and eat it too. Otherwise, I'll call the commissioner, let him come and explain. This is not the way things should go. You're going to be very careful.
because online, I think or either big business, license to be made in online.
No, correct. Online board. Now, where is your finding that he's doing business beyond what he is allowed to do?
He is allowed to pay maximum business, whatever it is, but.
No, that's not what you said.
That is what he needs to pay the maximum.
Correct.
One person who goes in hundreds of crores, he will also pay that one.
Correct. So what is the turnover business that he is allowed when he pays 2,750?
That I will fix because these are not in the, that portal. So what it has been amended, then maybe put the online portal and all.
What is, how do you charge 1.5 lakhs penalty?
10401, that's why I think the amendment one,
Ah,
that every day,
every day. And that means for how many days have you charged? What, why?
for the date of.
When did you do the checking?
Hello. Here, the.
When did you do the checking?
Then, it will be minus, 36, is 40 minus, 36, 2020.
So 3623, you did the checking. Now, as per your rate, you can charge him 5,000 rupees per day. You check today and you charge him 1.5 lakh.
So, that is, first, if that will be charged from the date of 1st January to the, first, April, the moment they will take out that, they will not take out that, number of days they will charge, calculate. Because this person has taken about a trade license for that particular year. Or, that particular year, and from the 1st April of the particular year, on the day of.
So you calculated it from 1st April
Process, they have to calculate it for.
till 30th June. Correct? Now let me tell you something. In a 1 month, there are 30 days. Okay? In April, there are 30 days. In April, multiply by 5,000, 30 into 5,000 comes to 1.5. So you should have taken from him April 1.5, May 1.5, and June 1.5. You should have taken 4.5. Why 1.5?
That calculation, I don't have it now.
Yes, that is what you are doing as you want. As you want. And where is your finding that yes, he's been doing this all along? Nothing is it.
All along, he has not been doing it. That's why I'm saying that page number 21, he has been.
That is why I'm asking you. You just told me just now that he has been charged on the basis of 5,000 from 1st April.
That's why, my lord, I am.
If he charged from 1st April to 30th June is 90 days. In fact, 91 days. Multiply that by 5,000 comes to 4.5.
Well, that's why.
You are just making up as you go along.
That's why, my lord, page number,
I think that, huh?
Page number 21.
Yes.
Because that it been here paid, that Case number 20 also. Had it been with the maximum amount of 10, that trade license would not have, the issue of trade license would not have come. Only thing is that the designated place area would have come. He is now he's taking it a designated smoking area.
That is, okay, that is a sufficient, no? That's not,
Lot will not have preliminary issues.
no, no, no. Yeah,
Yeah, writ petitioner has not, were entitled to come to writ petition, writ court, and in the writ petition. It's a proprietorship farm, proprietorship farm. And all partnership is fixed by section 59 of the Act, Partnership Act. And it is a non-registered partnership farm.
it has to be registered where?
It has to be registered, my lord.
Where?
Where?
I don't know, you tell me.
Where? We have to, under the registration act, my lord, they have to register it. And they have to register it, then only they can file a writ petition. But I'll taking the decision of the court.
I've heard you.
What is it? They have made the decision for that, unregistered firm cannot file a writ petition.
This is a partnership firm, it's not a, this is a partnership, there's
Yes,
nothing.
partnership firm also, they have to
This
register.
is not a firm, this is a partnership. No,
No, it's a
a partnership,
partnership firm. What you will see the
partnership. Yeah, and both the partners are here.
yeah, partnership, what is the
Yeah,
page number 3, my lord, the partnership firm, it's a partnership firm, my lord.
How does it matter?
Well,
Both the
partnership firm-
partners are here.
No, there are three partners. Two partners are here. One has been excluded. That's why I say that each section 69 of the partnership act. And how the partnership has to register, it is the one of the, one example, my lord. You have to register it, my lord.
How many partners are there?
Two working partner, one sleeping partner. He's only getting salary, but he is not involved in any business.
It is one of the
And
example how the
section
partnership
69,
has
my
to
lord.
register.
But section 69 is something else.
Huh?
Section 69 is something else. Section 69 is regarding no suit to enforce a right arising from contract or right conferred by the shall be issued in any court of law by on the behalf of any person. So actually, regarding contracts, I cannot do, if under the part, other people, I cannot do regarding any contract.
May I continue, my lord?
Not to take considered third contract. And you know, that part. Section 69.
Think of the
Section 69 cannot be a bigger
69 of the
matter.
partnership act.
I think, you have to, where is the money now with them? You have paid.
With them.
So please kindly see the-
I think you should deposit the money in this pot.
so please think of it, section 69 of the partnership act.
Wait, I'll think, let me pass the order. We'll see, we'll pick up your issue work. Alright. Mr.
Yes, sir.
S. Sharma, learned counsel for the petition. Petitioner. Also has Mr. L. Boris, learned standing counsel. Guwahati Municipal Corporation. The petitioners have challenged the this is a receipt or what is this? Page 40, the receipt has challenged the imposition of a fine of rupees 1.5 lakh. In terms of the receipt dated 30/06/23 issued by the GMC authority upon the petitioner on the ground that he has been running his restaurant business with the invalid trade license and serving hookah without trade license. The petitioner's counsel submits that the petitioner has paid his license fee for the trade licenses that were issued for the relevant period of time. And that was issued, that was issued, huh? For the relevant period of time, that is period of time, and as such, there was no ground for the GMC imposing a fine of rupees 1.5 lakh on the person. It says for the learned standing council GMC. On the other hand, submit that the petitioner has submitted a license fee of rupees 8650 for the year 2022-2020 and rupees 2750 for the year 2023-20. We submit that in terms of the fourth schedule to section 180 of the Guwahati Municipal Corporation Act 1971. Here and after refers to as the Act. The maximum license fee proposed, the rate of the maximum license fee was rupees 7,500. Wherein a company or association or body of individuals, the paid up capital of which is equivalent to 20 lakhs of rupees or upwards, and the date mentioned in Annexure 1 are being run. It submits that the petitioner's restaurant is a luxurious restaurant. And as such, the payment of license fee of rupees 2750 for the year 2020 as against the earlier payment of rupees 8650 showed that the petitioner had given a wrong disclosure in the online portal for the year 2020. As such, there was no infirmity imposing a fine on the petitioner due to doing business with an invalid trade license. It says Dora also suffered that serving of hookah does not require a separate trade license. However, as the restaurant was petitioner's restaurant and how the petitioner had paid the license fee of rupees 8650 earlier. It was clear that the petitioner was not with was clear that the petitioner had made a wrong disclosure in the portal while submitting his license fee for the year 2023-20. As such, comma, in terms of in terms of where is that 5,000 per month? Huh?
That does not apply to,
Huh?
that does not, that 5,000 does not apply to my case.
Anyway, no, I'm just his submission, he can say anything.
All bunch of people.
Huh?
All bunch of people.
There's no paper there, it's with you, I think.
Oh, what is it? I have related one.
My,
No, no. This, as such. Whatever I said. As such, in terms of the amended section 404 bracket 1 of the Guwahati Municipal Corporation bracket Amendment Act 2021. The respondents were competent to impose a fine of rupees 5,000 per day for contravening any provisions of the section, any provisions of the Amendment Act, Amendment Act, or failure to comply with any requisition made in pursuant to the provision therein. It submits that the petitioner, it submits that the fine had been imposed upon the petitioner with effect from 1st April 2023. Correct? Next paragraph. Next. What else?
What is it?
Huh?
Okay.
This is a,
That one is the best.
it's not a luxurious.
Not like that, which comes under 20. Okay, next one, 20. Next one.
Not, it's not luxurious, AC restaurant.
On page 194. Here number 2. 194. Here number 20.
Next paragraph. That's all I think, that's the
That's the
submission.
matter maintained with the partner. This is a partnership.
Next paragraph, the Mr. S. Bora further submit that the writ petition is not made eligible in as much as
Being a partnership firm, unregistered partnership.
This petition has been filed by an unregistered partnership. firm. And what is the judgment that you rely upon? Hello, I will hand you over the. All of. Unregistered firm. In terms of section 69 of the Indian Partnership Act 1930. In this respect, shall relied upon the decisions of this court. In the case of All India Road Transport Agency versus Indian Oil Corporation Limited. 2016, 1 GLR 229, Kumud Kachari versus Rajdhani Tractors and Agencies. 2017, 2 GMT 309. And in the case of Ranadhir Dev Roy and others versus State of Assam and others. 2002 GMT 517. That's correct. On the other hand, the counsel for the petitioner submitted. The repetition is maintained. We'll list it some other day, no time. We've got, I've got, it is, to be here. When do you want? Why not? It's convenient for you. Huh? This is the matter on Saturday. Okay. Here is your affidavit, you know. Okay, you get paid. Okay, right. Heard, Mr. D. Chakrabarti, learned counsel for the petitioner. Also heard Ms. DJ, learned counsel for the. 1, 3, 4, 5, 6, and 7. Who is for 2? 2 is. Madam, Mr. B. Gogoi appears for point number. The petitioner's case is that on 25/9/2019, it is take. I think the synopsis. I think they're all correct, no? Grammar is correct, man. Except for the last line. Ms. DJ, then it's counsel for the petitioner. For the response number 1, 3 to 6, 7. 1, 3 to 7. Submits that. The claim of the petition is not denied by the response. And as such, payments can be made to the petitioner as and when funds are made available to the respondent number, to the respondent. On perusing the orders of this court, this court finds that Ms. D. Jain, learned counsel for the Water Resource Department, has also made the same submission on 29/5/2025, which is to the effect that the claim of the petitioner was not denied by the department. However, she needed 2 weeks time to file affidavit. Next up, Ms. D. Jain has however not filed. Let me continue, huh? Ms. D. Jain has however not filed the affidavit. However, in view of the fact that there is no denial of the petitioner's claim by the respondent, the respondents are directed to pay to the petitioner his total outstanding bill amount of rupees 1,44,11,300 within a period of 6 months from the date of receipt of a certified copy, which is according to this question. No one appears for the parties on call. Accordingly, in this matter, no, no one appears for the petitioner. Petitioners on call. Ms. Udas appears for. And just a minute, I'll just say. Ms. Outer respondents are the state of Assam is presented by Commissioner Secretary Tribal Affairs. No. Then Principal Secretary Tribal Affairs. I'll just say that, huh? No one appears for the parties on call. Accordingly, leave this matter after 2 weeks. After the vacation. This is shifting of the IMFL
yes.
offshore.
Actually, my lord, there are 2 judgments of our High Court. It has been said, any before 13/3/2020, it should not be taxed. And that is again reiterated in a subsequent judgment. So I'll be relying on that. And moreover, my lord, this is not an educational institution. Their institution is at a place called Bamunga, Ahunga. If we go by what is the definition of education institution, my lord, because there are, look, it's a 2-room in
No,
a
no,
particular building.
You are for whom?
I'm for the petitioner, my lord, the liquor shop owner.
So you had asked for transfer.
No, I have not asked for it, sir. He said, that actually wanted to plan. There is a commercial property called Bora's Company, Bora Company. Here, my shop is situated, and in the first floor, my lord, a particular education institution was established. That is subsequent to my thing. But when the permission was given by the government of Assam, they are supposed to set up the college in Ahunga. All these, they themselves have brought out these documents. In any case, my lord, there are 2 judgments of this honorable court that licenses prior to 13/3/2000 it cannot be given. And it is reiterated in subsequent.
Who are we waiting for then?
Actually, that is complainant. Plus, excise department is also.
Okay, right. Mr. K. Chaudhary appears for the petitioner. While Ms. Udas appears for the point number 4. No one appears for the excise department or for the private department. Accordingly, this is matter. Then. Okay, this is the matter after the meeting. Interim order to proceed.